Welcome, everybody. Welcome to this episode. Here we talk about legal and regulatory risk. This is episode 2 under Understanding Cross Border Trade, Legal and Regulatory Risks. Overall risk is what we see in this section. Cross border trade operates within an intricate framework of international treaties, regional agreements, national regulations, and it creates a landscape fraught with multiple risks, including legal and regulatory risk. These risks emerge from non-compliance with the diverse requirements, guidelines, misaligned expectations, wrongful enforcement of the contracts, sudden shift in the regulation, and it could be due to geopolitical or economic changes around. Failure to navigate this complexity can result in severity of the losses, including fines, seizures of goods, reputational damage, and disruption of the operations. For example, if an European exporter unknowingly and unwillingly violated an US sanction by shipping dual use technology through a third country, they could face penalty and exclusion from US market, which is a very heavy price to pay. So compliance with international trade law is very important and non-negotiable aspect of cross-border trade. Sanctions are powerful tools used by the government and international organizations. When you're participating in a cross-border trade, you are operating under overlapping laws and regulations. The corporate must navigate national, regional, and global requirements. Complying with the regulations is a great challenge. Violation can trigger greater pain. Organizations, be it a government entity or a private corporate, face financial loss or financial sanction or penalty, disruption to their operation, and a damage to their reputation. Not only that, even though there are laws, sometimes getting a law implemented is difficult because of the inconsistent interpretation and inconsistent application of the rules across the jurisdictions. And this creates unpredictable outcomes. So sometimes enforcement is significantly different and difficult between different countries. Sanctions are powerful tools. They are intended not only to enforce foreign policy, but also to curb illicit activities, to address human rights violations, to prevent terrorist financing, and to stop money laundering. They introduce significant compliance challenges for the corporates and the banks engaged in international trade because violation can lead to crippling penalties. Sanctions are coercive measures. It could be economic, financial, diplomatic. It could be on individual, institution, corporate, government, or a region. They are imposed to influence a certain behavior and prevent some other behavior. They are meant to deter. They are meant to isolate. They may target sometimes only certain sectors or certain products. Economic sanctions restrict trade, investment, or financial transactions. Example, US sanction on Iran oil. Embargoes. They prohibit all trade and economic interaction with the country. Example, US embargo on Cuba. Targeted sanctions. They focus on certain individuals or entities or sectors. Sometimes it is only asset freeze or travel ban. Then comes the secondary sanctions because they penalize non-sanctioned parties for engaging with sanctioned entities. US countering America's adversaries through sanctions, CATSA, is a special act that punishes firms for trading with Russia's defense sector. Now, who are the key sanctioning entities? One is United Nations because they impose globally binding sanctions, such as those on North Korea for nuclear proliferation, for example. Then comes the European Union because they coordinate sanction across 27 nations, the member countries, targeting regimes like Syria, for example, for chemical weapon use, or Belarus for election fraud. US Office of Foreign Assets Control, or FAC, Office of Foreign Assets Control. They administer sanction extensively with extraterritorial reach, and they impact non-US firms via US dollar based transaction. So the US sanction is if you are using US dollar, whether you are in US or not, whether you are governed by an US regulator or not, the sanction applies to you. Then comes the UK Office of Financial Sanction Implementation. They enforce post-Brexit sanction, aligning closely with the EU and US policies, but with independent measures. For example, they target Myanmar's military junta for the anti-democracy activities. Then there are other players like China, Canada, Australia. They also have their own varying sanctions to various entities. Example, China sanctioned the EU officials in retaliation against the Xinjiang related measures. Now, what are the mechanism or what are the impact? The most important is trade disruption. The most important is trade disruption. Sanctions block access to market or to inputs. Then the cost of compliance, because firms have to invest heavily on the applications or software for screening for the data to prevent violation. Then comes the reputational risk. The reputational risk happens if you fail to comply with the sanction and if you get sanctioned because it erodes a stakeholder trust. One example of case study is that Russia invaded or had a special military operation in Ukraine. Then the US, EU, and other allies imposed sweeping sanctions, including swift ban, asset freeze, export ban on technology and energy of Russia. This affected multinationals like the US company BP or Shell working in Russia. They had to exit and that suffered losses of almost 25 billion. Then the compliance challenge. Secondary sanction was imposed on certain entities in India, Turkey, etc. to prevent them from dealing with Russian trade. Then comes the legal consequences. For example, UniCredit had to pay $1 billion for violating US sanctions on Iran. And what is the lesson? The lesson is that real-time monitoring is a necessity. Sanctions are evolving every day, and there need to be extreme care to avoid inadvertent violations. Then what are the export controls and compliance challenges? Screening business partners is what corporates will have to do. Having a program to maintain compliance with sanctions all the time. Have the processes updated and the data updated. That is another requirement. Go in for export license or import permission whenever the goods are suspectedly dual use, etc. And then monitor where the end use, who is the end user of the goods and where it is going to prevent violations. Looking at Russia sanctions, as we said, the sanctions have been very comprehensive. Firms had to suffer losses. It impacted not only the sanctioned entity but also third parties, and there were some enforcement actions also. Enforcement of sanctions sometimes have challenges because of the jurisdictional conflict. The local regulatory or legal system may say the overseas entity have no right to sanction. Sometimes companies must decide which country's law has to be applied. Sometimes there could be dispute due to competing jurisdiction over the same case. Then comes the foreign judgment. Some court decisions may lack enforcement abroad. Then winning a case does not guarantee collection of funds because assets must exist in the jurisdiction who is willing to enforce the judgment and collect the proceeds. Then comes the immunity barrier. Some governments can resist enforcement. State-owned enterprises will claim immunity. Then political relationships influence the outcome. So a corporate needs to have backup plans. Export control and compliance regulation. What is it? Because export controls are the laws that restrict sale, shipment, or transfer of specific items. It can be part of sanctions or otherwise. For example, the Wassenaar Agreement is a 42-country agreement harmonizing controls of dual-use goods. The US Export Administration, they have the Bureau of Industry and Security, which decides what can be commercially exported among the dual-use goods. Then you have a EU dual-use regulation of 2021, which has some 800 odd items. Then has the China export control law, which prevents sensitive technology going out of China because US has restrictions against China, and goods such technology cannot go to China, and China also does not want to share such technology with anybody else, especially because of the rare earth minerals that are available. Then there are other regimes which also have sanctions. So screening the partner, licensing requirement, compliance with those things, monitoring the end use are the expectations that a corporate will have to do. And this is difficult because the challenges are in the form of complexity that is overlapping, then extraterritoriality because some courts or some jurisdictions may not recognize the sanction, and then the rapid changes in the sanction or the applicability, the geopolitical shift. That is what is another challenge that the corporates will face. For example, if you just like Russia sanctions, you had a China Huawei sanction. When Huawei is added to the was added to the restriction list, Huawei smartphone sales dropped to 50% globally, and their suppliers suffered a lot. They halted shipments because they could not do a US dollar shipment. So there were global consequences, and China had pushed for self-reliance in technology, and the domestic chip makers like SMIC, they triggered EU debates over the dependency on the US technology. Then there were legal battles. Huawei filed lawsuits against the US. The lesson that we learn from this is that export control can reshape the whole industry, not just a corporate or a firm. This will require the firms in the sector to diversify. Similar problem was there in the ZTE case also, which was almost about to collapse. What we need a robust compliance program, automation of the screening, internal audit, classification of different goods and documents. We need dual diligence. The due diligence in the corporate level should be on the counterparty, know your customer, know your business, know your customer's business, know your counterparty's counterparty. We have to map the supply chain, who the goods are going to, from where goods are coming from. Are they compliant enough with respect to compliance requirements? Then comes the red flag monitoring. Watch for suspicious patterns. Is a transshipment or something happening, etc. We as a corporate need to have training and awareness program, be it in the form of employee education, be it in the form of incident reporting, or in the scenario planning to stimulate and prepare for the worst case scenarios. We also need to engage with the legal counsels to ensure specialized advisors are there for specialized tasks. We need to have license agents who will deal with the regulators in case there is a misunderstanding. And then we have to be prepared for resolving the disputes. Now comes the question of contract enforcement. There are various challenges in enforcing a contract because cross-border contracts have multiple legal systems trying to adjudicate. So there are cases are heard in some country according to some other country's law, and a decision is passed which needs to be implemented in a third country. Sometimes the judgments are not enforceable. So these introduce delay, additional cost, and unpredictability. The challenge is because of the different traditions like civil law or commercial law or hybrid systems. So the choice of law in the contract has a say. The selection of a forum who will arbitrate in which court, in which venue, under which law, that will have a say. Recognition of a foreign judgment. So that enforcement of a judgment is difficult. China enforces US judgment selectively, citing sovereignty. Then comes the cultural nuances because of the interpretations are different and it will complicate the intent. Japanese firm's good faith clause was misinterpreted in Brazilian court favoring the local party. So they said the good faith is on Brazilian party, not on the Japanese party. So these things may happen. What are the mechanisms or the impact of this? Because of these different laws, you may face impact in the form of a delay, impact in the form of a cost, and impact in the form of a loss because of non-enforcement. For example, look at the Apple versus Samsung case where Apple and Samsung filed a patent lawsuit. This patent lawsuit went over in 10 countries, including US, South Korea, Germany, Japan, Australia. And this is over the smartphone design, which are sold in over 100 countries. So the courts applied local patent laws. US awarded Apple 1 billion for infringement, while South Korea fined both the companies, and Germany banned certain Samsung models. So different people suffer differently. Legal costs exceeded 500 million because, and the outcome was inconsistent. It confused the market. supply chain faced disruptions. And then this fragmentation highlighted the need for clear terms in the contract. Then take the example of Chevron. Chevron faced a 9 billion Ecuador court judgment for environmental damage, which it contested as fraudulent. And this triggered lawsuits in Canada, Brazil, and then it had to lead for arbitration. The lesson is that sovereign bias in a local court is something that one need to be aware of. Then comes the arbitration. What is arbitration? It is a preferred alternative to litigation for a cross-border dispute because it offers neutrality, speed, and enforceability. But enforcing awards, sometimes we may have to face some certain challenges in certain jurisdictions because some systems may be weak or there could be interferences. What is neutrality? It avoids bias to local court. What is speed? The resolution of the dispute could be in months, not in years. Confidentiality? It protects a sensitive business information or data, and there is no risk of a public trial. Enforceability. New York Convention is enforced in lots of countries. Expert adjudication, because not like a court where you have only judges who are specialists in law. Here you can have arbitrators who are specialists in your field of business, potentially better for the corporate. What are the frameworks? One is the New York Convention. It is as old as 1958. It was signed, and there are 172 countries who are signatories of this convention. And some procedural flaw are there or public policy conflict. Otherwise, they are good. For example, UK firm enforced the 5 million Singapore award in India under the convention. UK firm enforced the 5 million Singapore award in India under the New York Convention. Then comes the investor-state dispute. This disputes between investor and the government. Then comes the regional center, like ICC Paris or LCIA London or Dubai Arbitration Court or Singapore Arbitration, etc. What are the main challenges? Again, the challenge that we face here is the sovereign immunity or allegation of corruption or public policy exception. Most importantly, asset tracing. Locating the asset to enforce the award for liquidating them is very difficult when they are state-owned entities. Because when there was an arbitration award against the Libyan government, the Libyan assets post-Gaddafi could not be identified or seized. Corruption allegation is that in 2016, the Nigerian award was overturned after evidence that arbitrator was having a misconduct. There is also an example where a Saudi court rejected a UK award citing Sharia law conflicts with what has been awarded. So these are some of the challenges. So what risk mitigation we can look at? One has to look at the context, one has to look at the impact, and what lesson we learned from a previous historical case, and accordingly draft our contract. For example, Pakistan was ordered to pay 5 billion for denying mining license to a copper company which is a Australian link. Pakistan challenged the award saying sovereignty and delayed the payment. And then the entity, Tetian, sought enforcement in the US, Australia, targeting Pakistani asset. So this will lead to investor-state dispute because the copper giant had invested in Pakistan for mining metals and minerals. So in such situations or in such contracts or investments, it is very important to draft a clear dispute resolution clause, preference for arbitration. The clause should be detailed and there should be fallback options. That is include mediation before arbitration to reduce the cost. Go in for political risk insurance because it has to help you to protect against expropriation or inconvertibility of the currency or breaches by the government. For example, a US firm insured an African project for 100 million because to protect against a government takeover. Then comes the local legal partnership. You need an in-country expertise in every country because the nuances are different and you need to navigate the, what do you call, local culture. Then comes the cultural alignment. Local partners are required to bridge the gaps. For example, a French exporter will have to use an Indian attorney to negotiate settlement terms with an Indian company so as to avoid litigation. Then is to have a network. For example, UK SME will have a Dubai DAFC court to settle Middle East related activities through their Chamber of Commerce so that they know whom to talk to and how to interpret. What are the other strategies that you can adopt? One of them is to have escrow accounts. One of them is to seek a performance bond, etc. So, any corporate engaged in cross-border trade will have to have multiple strategies to navigate the legal risk or a regulatory risk. You need to document what is being done and why it is being done and how it will need to be done in case things are not as per plan. The due diligence on counterparty to understand who is the ultimate beneficial owner, the parties and places and everything need to be screened for sanctions, and then whether the screening is happening on a good reliable system against the latest current list is what you could look at. You should also be looking in a contract what is the governing law, which court has a jurisdiction, is there an arbitration, is there a mediation, how it will be interpreted, and whether a local attorney has given their local input to ensure non-compliance with the cultural or other regional nuances. Then you need to go for political risk insurance. So these are some of the risk mitigation measures that you can take up. Now, legal and regulatory risk is stemming from sanctions, export controls, contract enforcement, etc. So it is very clear that we need a meticulous planning and proactive management. But it is not too much to worry because 172 countries follow the New York Convention. More than 1 billion has been sanctioned or penalty has been levied on Society General for sanction. That gives enough message to understand the need for sanctions compliance. UN, US, UK are the different parties that are sanctioning in addition to other major countries. So we need to be aware of the different sanctions and we need to be online real time on the changes in the sanctioned entities. The essential steps to mitigate these risks is comprehensive compliance program, thorough due diligence, and strategic contacts and contracts. These are what will help us to navigate the sanctions environment. Thanks for listening to this video. This is episode 1.2. We will catch up again in the next session on understanding trade.